An economic theory of tort law. The early law asked simply, did the defendant do the physical act which damaged the plaintiff? The law of today, except in certain cases based upon public policy, asks the further question: was the act blameworthy? Uh, James Barr Adams, Law and Morals, 22 Harvard Law Review, 97, 98, open 1908, close. It's obviously year 1908. Even if there is no negligence, public policy demands that responsibility be fixed wherever it will most effectively reduce the hazards to life and health inherent in defective products that reach the market. Escola v. Coca-Cola Bottling Company. Judge Roger Trainer. Again, Escola v. Coca-Cola Bottling Company. 150 Big P dot 2D 436. Year 1944. People often harm each other by doing something wrong. Motorists collide on the highway. Patron in a bar punches the person next to him. And intrauterine birth control device, intrauterine birth control device causes infertility. A newspaper inaccurately reports the arrest of a businessman for soliciting a prostitute. A professor gives an unfair exam, and so forth. Some of these wrongs are accidental, and some are intentional. Some are serious, and others are trivial. Some are crimes, and others are annoyances. Suppose that the victim in each of these cases initiates a lawsuit. Under what body of law can the victim sue? Because the plaintiff and defendant are private persons, not the state, the suit belongs to private law, as does contract and property law. The victim cannot sue under contract law, which we will discuss in later chapters, because a broken promise did not cause the injury in any of these cases. The victim cannot sue under property law for damage to body, reputation, or scholastic record because these things are not property. You cannot transfer your body, bequeath your reputation, or sell your scholastic record. Large losses can escape contract or property law, such as the explosion of British Petroleum's Deepwater Horizon oil rig in the Gulf of Mexico in 2010 that resulted in billions of dollars of losses, as well as uh, dead birds, fish, and aquatic plants. These facts demonstrate the need for a third major body of private law other than property and contracts. The third body of law concerns compensable wrongs that do not arise from breach of contract and cannot be remedied by an injunction against future interference. Here are some more detailed examples. Example 1: Joe Potatoes has been driven to distraction by the escapades of his wife, Joan Potatoes. At the end of a hard night's work at loading dock, Joe is approached by Jim Bloggs. Suspecting that Jim has been romancing Joan, Joe insults and strikes him, breaking his nose. Bloggs subsequently sues for the injury to his reputation and nose. Example 2. Three hunters go into the woods after pheasants. They're spread out in a straggling line, about 25 yards apart, walking in the same direction. The hunter in the center flushes a bird that flies up, its wings pounding. The hunters to his left and his right turn toward the bird in the middle and fire. The bird escapes, but the hunter in the middle is blinded by birdshot. One of the two hunters certainly caused the harm, but there is no way to determine which one of them it was. The victim sues both of them. Example 3. A manufacturer produces automobile fuel additives that demand careful control over quality. If quality control is maintained at a high level, the chemical mixture in the product is correct, and it never causes damage to automobile engines. If, however, quality control is relaxed and allowed to fall into a low level, some batches of the chemical mixture will be flawed. A few of the cars using the flawed batch will be harmed. Specifically, the engine will throw a rod and tear itself to pieces. After a rod is thrown, an alert mechanic can detect the cause of the harm by examining the car's fuel and other signs. The manufacturer determines that a high level of quality control costs more than the harm to some automobile engines caused by a low level of quality control. So the manufacturer adopts a low level of quality control. The owner of a damaged car sues the manufacturer and asks for punitive damages. In English language countries, the name for the body of common law relevant for these cases is tort law. After the Normans conquered England in 1066, they soon lost the French language, but they retained a peculiar form of it for writing about law. Tort is law French, itself derived from the Latin words tortus, twisted. The common law of torts overlaps the law of civil responsibility in continental Europe. The continental Europeans use this phrase to refer to private suits over injuries as opposed to criminal prosecutions. However, different legal traditions locate the boundaries of these broad areas of law somewhat differently and adopt somewhat different legal doctrines. Example 1 illustrates an intentional tort, so named because the injurer intentionally inflicted the harm on the victim. Many intentional torts are also crimes, such as assault, battery, false imprisonment, and intentional infliction of emotional duress. The person who commits such an act may be sued for damages under tort law by the victim and also prosecuted under criminal law by the state. Intentional torts are so much like crimes that we will not discuss them here. Instead, we shall rely upon the analysis of crime in Chapter 12 to serve as an introduction to intentional torts. Most of the wrongs that we shall consider in the two chapters on torts are unintentional, that is, inadvertent accidents. To illustrate, example 2 describes a hunting accident. Example 3 is more complicated. The manufacturer's low level of quality control is deliberate, and the resulting harm to automobiles is statistically predictable. But the harm to particular cars is accidental. Example 3 also differs from the other two examples in that the injurer sold a product to the victim, so the two parties participated in a commercial transaction. The law of accidents was one of the first bodies of private law successfully analyzed using formal economic models. Following the pattern throughout the book, this chapter focuses on general theory, and the next chapter turns to particular topics, including proposals to reform the tort liability system.